Many times at our firm, we receive questions about inheritance and what to do about judgments. Here's a recent question that I thought I would share with all of you. What happens when an ex-spouse dies and still owes child support? Hi, I'm Christine Mattis of the Mattis Law Group, and here is an interesting question. Is the beneficiary of a will required to pay judgments against the deceased from proceeds of an inheritance? The question goes on. My ex's mother recently passed away, and he owes me a child support judgment and another judgment. His brother is the executor of the will, and I would like to contact him about the judgments. Signed, ex-wife. Well, the answer is yes. You should absolutely contact your former brother-in-law about the money that you're owed. According to New Jersey law, if your ex-husband's inheritance from his mother's estate is more than $2,000 and he is the subject of an outstanding child support judgment, his brother, as executor, must not distribute your ex-husband's inheritance to him until the child support judgment is satisfied to the extent made possible by the amount of the inheritance. Your ex-husband's brother should be made aware of the child support judgment so he can ensure that it is satisfied as much as possible. Now, even if you don't contact or notify your ex-husband's brother about the judgment, your ex-husband's attorney, or if he has no attorney, your brother-in-law as executor is obligated to perform a search of child support judgments to determine if one exists against your ex-husband. Your ex-husband's brother-in-law also is obligated to contact the probation division of the New Jersey Superior Court to arrange for the child support judgment to be satisfied in whole or in part, depending again on the amount of the inheritance. If he doesn't perform these steps and he decides to distribute your ex-husband's inheritance to him, he can be held personally liable for the child support judgments. The child support judgment has priority over any other claims against your ex-husband's inheritance unless a court has directed otherwise or the claim is for unpaid New Jersey income tax. So, if the amount of the child support judgment equals or is more than the amount of your ex-husband's inheritance, then it's unlikely that you'll be able to collect on your second judgment if you had one. If the inheritance is enough to satisfy both the child support judgment and all or part of your other judgment, you can act to collect. Again, New Jersey law allows you to file an action to collect on the judgment if it was entered in the last 20 years. This type of action is filed in the Special Civil Court of the New Jersey Superior Court. You may ask the court to collect the judgment from your ex-husband's inheritance and include both him and his brother in the capacity as executor of their mother's estate as parties so that he cannot withhold the amount owed pursuant to the judgment. If the judgment was entered over 20 years ago, you can file an action to revive the judgment and collect on it. If you're successful, the court will then issue a document called a writ of execution that empowers a court officer to collect the amount of the judgment from your ex-husband or from his mother's estate, depending on where the funds are then being held. So as you can see, this can feel overwhelming. And if you are still not sure on how to collect on a judgment when an ex-spouse dies, please contact our office by clicking below. We are a law firm experienced in estate administration, and we'd be happy to speak with you and find out how we can help you and your family.